Hello friends, welcome. Friends, today I saw a very important article which talks about Anthropic wins an early round of music publishers AI copyright case. Now this has been covered worldwide and this is considered to be a very important milestone in AI's ability to continue to add value and grow their product and their business. Now, friends, you all know that copyright is a very, very important issue which is still not settled legally in any of the courts and anywhere else in the world. In India, also there have been a lot of cases of copyright files has been filed against OpenAI, and there are plenty of other cases going on in the US and other parts of the world. Now, friend, I am pretty interested in the legality of copyright because I understand that how copyright can dismantle the whole AI industry or can unlock huge value if these cases are properly structured and then finalized and settled. If these are not settled properly, then AI industry can be irreparably harmed because the whole structure of the AI industry is going to fall apart, and how the common man's lives are going to get impacted, because today everybody is directly impacted by artificial intelligence to empower their skills, and artificial intelligence has other kind of negative impact on the society because it is kind of diminishing the normal people to carry out livelihood, which will probably will get replaced by AI. So friends, in this video, I am going to talk about the nuance of this case and compare with an article which I did recently, which talked about how AI cases, especially the New York Times versus OpenAI and Ross versus Thomson cases, were different in nature, what arguments were used in those cases, and what argument is being used in this particular case, which is Anthropic versus Concord. Now, what is Anthropic? Anthropic's website is this. They have a product called Claude, and Claude is a AI research product that puts safety on the frontier. This is their website. And Concord is a music company. You can go to this website and you can visit this website. Just to summarize this discussion properly and to structure it in a manner that it makes sense, I have put some slides. And I am going to go through the slides and the judgment which was issued by the California District Court, where the injunction request of the music company, which is Concord, against Claude was rejected. So we are going to talk about that. And friends, don't get overwhelmed by this discussion because you will find this discussion pretty simple. Just be with me, and if you have a logical structure of mind and you are able to understand common logic, you will be able to understand these cases and how these cases are different from each other. Okay, so let's go with that. So first is, what is Claude? Legally speaking, we have already spoken about it. Claude is a general purpose language model, not a music product. It doesn't generate any music or play music. It doesn't sell music. It doesn't offer lyrics, music recommendation, or substitute for a product of Concord product. And the court says that Claude is not directly in competition with Concord's code business or licensing lyrics. It is not a substitute product. Now, what is Concord? Concord is a music company and is a music publishing company. It owns a copyright, it licenses these works, and it collects royalty and pays and supports songwriters. So this is the essence. Now, friends, in the earlier article which I showed you here, this is the article that I had written earlier. This compared the New York Times versus OpenAI case and the Ross case. So if you see that, if you are interested, you can go through this article, but I would like to summarize this article in this slide. So let me just go into this slide, because there are three important cases which needs to be compared with each other, which will kind of draw the flavor of what is going on. One is Ross versus Thomson. Another is New York Times versus OpenAI. Another is Concord versus Anthropic, which is the recent case, right, which we are discussing. Now, the New York versus OpenAI case is still in the process of litigation. It has nothing has come out. I went through the complaint, and based on the complaint, I have summarized it. Ross versus Thomson, there was a preliminary order, right, which is very, very substantial, a judgment which was pretty, very substantial, and that has been summarized in that article which I just showed you, right? So what I'm going to do is I'm going to just give you a brief, the key legal issues and the court's key finding. So what was the key legal issue in case of Ross versus Thomson Reuters? It uses the copyright legal head notes to train AI legal search tool, focused on fair use and competitive harm, right? Now, let me just give you a brief so that you understand. So what happened was, in this particular case, that Thomson Reuters is a legal search company. Means what it does is it basically analyzes all the legal court judgments. Physically, a lawyer will read those judgments and then it will create a summary. And that summary is called head notes, right? And then there is a key numbering system on which these summaries are going to be cataloged. And if you really want to understand that what is a particular case that you should use as a reference, you can go to their website. By looking at the head notes and the key numbering system, you will be exactly able to nail on those judgments, right, which you should be referring. Because there are plenty of judgments, you will get lost. So this Thomson Reuters provides the user an ability to nail and map those judgments, which is going to be relevant for their cases, because lawyers and other people need these kind of capability to become more efficient. So what Ross was able to do, was trying to do is, it was trying to offer a similar product by using Thomson Reuters head notes, which is nothing but a summary of those judgments. It read through those head notes and offered a competitive product. And therefore, the judge found that it was not a fair usage, because one of the major attribute of fair usage is that you are not going to create a competing product. Because here you ended up creating a competing product, with Thomson Reuters, with a similar capability, and you felt that it is much more efficient because you have used artificial intelligence. Here, there was no reproduction of those head notes. So you understand this, very, very important. So if there was a prompt, and if somebody gave the prompt, nobody was reproducing, the AI tool was not reproducing those head notes verbatim, which could have led to a direct copyright infringement, right? So the defense of Ross was that since there was no direct reproduction of those head notes, and therefore there is no copyright infringement. But the judge found that since you used somebody's copyright material to create a competing product, and therefore you are directly against the concept or the principle of fair usage, and therefore you are subjected to in compensation from to Thomson Reuters for having done that. That is the whole purpose of this particular case, right? That was the whole you can say the gist of the overall case between Ross and Thomson. Now, New York Times versus OpenAI is a slightly different case. Here what was happening is that OpenAI used New York Times copyright material, which anybody can access going to the New York Times website by taking a subscription. Now, when you go into New York Times website, you take a subscription, you can access those material. Now, these material can be available to somebody who has access to the New York Times website. So OpenAI used this copyright material in New York Times website to train their model. Now, that was fine as long as the OpenAI did not reproduce the New York Times material verbatim. So they reproduced New York Times material verbatim, and therefore it created a problem, because that is a copyright material that was not coming under the concept of fair use, where it has to be something transformative. Transformative means there is something more value that you should add. You should not be replicating the same thing. And not only that, when you replicate somebody's work, which is a copyright work, which is accessible by paying a subscription to their website, you are preventing the user to visit their website. So you are basically causing harm and revenue loss. So this is what is going on in case of New York Times and OpenAI. Now, what is Concord versus Anthropic? Now, here the issue is slightly different. Let me explain. Now, for that, I have to go directly to the judgment. Now, if you look at the judgment, you will notice that this judgment, which is very, very elaborative and very nicely written, though the number of pages in this judgment is only 13, but when I went through the judgment, I found the judgment very nicely written. So first it goes on to give the factual background, which I have already explained to you. So the point here is that Claude is using the copyright material of Concord to train their AI. That's simple as that. See, this is the allegation. So they are saying that there are plenty of copyright material which is available free in the internet, maybe the licensed, unlicensed. So they have plenty of music which Claude is using to train their model so that it can perform their job, whatever is required for the model to do. So this is one. The second thing is that if you go here, it basically says that there was definitely an allegation of verbatim or near verbatim copies of their work when you if you give a prompt, then the question about reproduction of Concord's material, which is used for training the AI model, was at risk. So there was an allegation, but this allegation was settled because what Claude did or what Anthropic did, they basically said that they have guardrails. Let me just show you the exact wording of here, which basically said that, because there are so many verbiages here, so I'll just go straight to the point where it said that the issue was settled, right? So here just let me pause the video and I'll get back to the point. Yeah, so there are two important issues as I mentioned here. One was that when you give a prompt, it kind of generates, there was a risk of it kind of replicates what the copyright material of Concord has created on which Claude is trained. So what they're saying there are two types of problems. One is output, another is Claude's input. So input is the material which is used to train Claude, right, which is Concord's copyright music material, which is used to train Claude. Another is output, which is the response that it generates from user prompts, right? So what it is saying is that with respect to output-based infringement, which is basically exact reproduction of Concord's music, the issue has been resolved. So this is what is very, very important here. It says the issue has been resolved. For this purpose, the motion by parties in recent stipulation. So the publisher means Concord originally sought a preliminary injunction ordering Anthropic to maintain effective guardrails that prevented its current and future AI model from generating output that reproduces, distributes, or displays the lyrics in whole or in part to composition owned or controlled by the publisher. So basically, what I'm saying is, the summary of this discussion is, there is an input, which is the input of Concord, the music material which is used to train the AI. Another is output, which Claude generates based on the user prompt. As regards output, verbatim reproduction of the input, that issue has been resolved. That's what it is saying here. So there is no question of this product competing with the Concord. So Claude is not in direct competition with Concord. It clearly establishes this. This clearly establishes this fact that there is no competition because this issue has been resolved. So the main point here is that the main point of this case is that whether the material that Claude is using, right, which is of Concord to train their AI model, which is licensed or maybe unlicensed material to some extent, which is available free in the website, is it fair? Is it done in a fair manner, or it requires an injunction that is causing huge financial loss which is irreparable in nature to Concord? That's the issue which was discussed in this particular case. And if there was the irreparable loss to Concord, then only it qualifies for an injunction. What does injunction mean? Injunction means that the court would issue an order and it would prevent Anthropic, right, and its AI engine Claude to use any of the licensing material which Concord has uploaded on their website. So it would have prevented them to use those material to train their AI model. That's the whole point about this case. And what the court found? The court found was that there is a principle called winter factors. Let me just show you what this principle entails. So there is a principle, a kind of legal jargon case. In legal jargon, they call it 4 winter factors. Now, you don't have to be a lawyer to understand what is 4 winter factors. So let me explain in a very simple form. To obtain a preliminary injunction, a plaintiff must demonstrate, right, the four winter factors, and all these four winter factors has to be established and proved. One is that likelihood of success of their case, means the plaintiff case likelihood of success on merits. Likelihood of suffering irreparable harm without an injunction, means if injunction is not granted, if Claude is not prevented from using Concord's material, there will be irreparable harm to the plaintiff, which is Concord. Balance of equity tips in their favor, which is plaintiff, means the case and the balance of equity tips in the favor of the plaintiff, and injunction is in public interest. And all factors must be satisfied, and the court found that none of the factors were met, especially the irreparable harm factor and the balance of equity tilted in favor of Anthropic. That's the point. That is why this case was dismissed. So let's understand this. This is about, injunction. This is when you use the word fair usage, right, then the product has to be transformative, means something totally different. It will not be competing with the product on which the model has been trained. So it is not the case here, right? And the second is that when you are using anything with a concept of fair usage, then you have to use it in a fair manner, which basically means one of the main critical ingredients is you will not be reproducing that material verbatim and prevent the user to visit their website and diminish their revenue, because it is typically the New York Times case versus OpenAI, where New York Times is alleging that OpenAI's verbatim reproduction of their content preventing the user to visit New York Times website, and there is a loss of revenue, right? But there is nothing of that is in this case, because this product is not in competition. And the other point here is that none of the four winter factor has been satisfactorily proved, and that is why the judge has not granted a preliminary injunction. The judge also has said that since the fair usage argument is unsettled, so let me go straight to because this is not going to serve any purpose by going through each and every word of the judgment, but it is very important for what the judge has said. Read this. The publishers are essentially asking the court to defend the contours of the licensing market of AI model, where the threshold on the question of fair usage remain unsettled. Because the court is saying that we don't know what the fair usage term really should mean from a legal centric, and what kind of guardrails and what kind of framework that the court system should establish to able to clearly say with certainty that when an AI is using any of the content, licensed content, then what kind of restriction should be imposed for the AI company, and what legal contours should be established so that there is a level of fair usage, which I have explained previously in my video. So there are certain principles which are vague, which are still unsettled, right? So that's in net about this video, friends. And I'll just go to my slide, the last penultimate slide, and we'll close with the final slide. Concord versus Anthropic, the core point. Concord main concern was unauthorized use of lyrics for training Claude. Concord is the music company, right? And the verbatim output was secondary and partially resolved. It is saying that it is partially resolved, but if you look at the judgment, it said that it has been resolved. But I am using the word partially because still the matter is not closed, and there are a lot of litigation and a lot of series of court hearings will take place. Now, court denied the preliminary injunction, holding that Concord did not prove irreparable harm. Monetary compensation could address their harm, right? Because there was no need to give an injunction, but you could have compensated monetarily, and that will get established in future hearing. Concord claim was vague, and the injunction could have crippled Anthropic's business. So this was the main argument. And now the summary slide says, unlike the Ross and the New York Times case, which focused on fair use and the reproduction of copyright material in output, Concord versus Anthropic turned out to be whether AI companies training on copyright lyrics just justified a preliminary injunction. This is the summary. The court denied Concord request because it failed the winter test, particularly on irreparable harm, and the relief sought Two was vague and potentially harmful to innovation and operation of Anthropic. So this is the net summary of this case, friends. I hope that you understood. I am not a lawyer, but I am an enthusiast because I actually understand, because of my past experience with Qualcomm. I do have understood patent cases in great depth of clarity. And based on that experience, I extrapolate some of the understanding from my experience in a very, very legal centric company. And therefore, I am able to give you this kind of insight, which in a form which is very simple and easy to understand. So friends, I hope that you have understood this case, and it will be useful for further appreciating what is going on in future regarding all these cases. And I'll keep myself updated. And as I update myself, I'll keep posting similar videos for the viewers to have a look at it, and that will be a win-win situation for both of us. And let's keep tab on these developments, because these are very, very crucial for the development of the artificial intelligence industry as well as for the common man. Thank you friends for your time. I'll come back with a new video next time on a new topic. Thank you very much for listening.